Greetings, my name is Ted Hicks. I'm the founder, CEO, and Chief Investment Officer for Hicks Associates Wealth Management. And today's video, we're going to talk briefly about estate planning. This is not designed to be an exhaustive summary on the topic, but just a high-level overview that I'm shooting this in direct response to a couple conversations that we've had this past week. First things first, a will is something most people should have in place, especially as you are accumulating assets. Now, again, we're not going to talk about a trust-based plan in this video. This is just the basics. So when we talk about a will, all a will does is it is telling the court system who should own the things that you've left behind once you go meet your maker. That's all a will does. Now, if you have children, frequently you are making suggestions to the courts about who you would prefer to be the guardians of your children. Now, in this past week, one of our clients made a comment that their mother had passed away recently, and our client doesn't believe she's mentioned in this mother's will or her mother's will. Well, if that is your intention, if your intention is to exclude somebody that's in your family, we would encourage you to say that specifically in the will. Yes, I am of sound mind, I have 3 children, but I'm specifically excluding this child. Now, there's lots of reasons people decide to exclude a child from their will, and we're certainly not encouraging you to exclude children. But if that is part of your plan, for whatever reason, we would encourage you to actually mention it specifically in your will, because it would avoid confusion. People are going to wonder, well, was this child supposed to be excluded? Well, if you say it specifically, you remove any doubt. Now, that said, if you do choose to exclude a child in a will, we would also encourage you to explain that in some shape or fashion. Once you have gone to meet your maker, you can't communicate with that child anymore. So we would encourage you to explain your decision. Now, we've seen people exclude children because they are estranged. They're no longer talking to the family for whatever reason. I've seen that happen. I've also seen it happen where, let's just say there's 3 children and one child is fantastically successful, but the other 2 children are not. And so the parents might sometimes exclude the child that is fantastically successful with the idea that, well, that child doesn't need any of my assets, the other 2 children do. That's fine if that is your decision. Remember, these are your assets. You can do whatever you want. But in a situation like that, if you're not explaining why you're doing that, you can leave a wound that may take a really long time to heal, if it ever does heal. So to prevent that, we would encourage you to leave a letter to that child so that they understand your reasoning. So that's wills. And the second point is beneficiary designations. I can't tell you how many times over the years that we've talked to clients and they say that they have a will and therefore they're not worried about their beneficiary designations. Well, unfortunately, I've also seen it where a client updates their will, but they forget to update their beneficiary designations. And this happened with an individual who was in a second marriage. The beneficiary designation pointed to the first wife. The will pointed to the current wife. Well, had death occurred, the first wife is getting those assets on that account. So again, on an account like a 401k or a life insurance policy, any type of account that has a beneficiary designation, the custodian of that account is not going to look at your will. They're going to settle the account based upon the beneficiary designation that you have on file. So typically when you go in and you meet with an attorney and you spend the time and the effort to draft a formal will or to update your will, you want to also make sure that you are reviewing and updating your beneficiary designations so that the beneficiary designations match whatever you're determining with the will. So the last bullet point for today is unfortunately something I've actually seen a couple of times, and this is where the individual says, well, I'm going to leave the assets to the first child or the oldest child, and I trust that they will split the assets evenly with their siblings in a fair manner. Folks, please do not do that, okay? That causes all kinds of conflicts after the fact, and again, you can't settle it. because you're dead and gone. We want to make it clear in your will and in your beneficiary designations, how do you want those assets to be split? Please do not leave your assets behind to one child, expecting that they are going to know what your intentions are, because legally they can keep all of the assets and they don't have to distribute them to their siblings. Now you might say, well, they would never do that. Well, we would argue you shouldn't allow them to even be tempted. If your intention is for multiple children or multiple entities, to include charities, if that's your intention, build it into your will. The last bullet point that is not on the screen is we would also encourage you to work with a competent and knowledgeable attorney that is specializing in estate planning. Hope today's brief video helps. If you have any questions, feel free to reach out to me or my team. We do have the office here in Cary, North Carolina, as well as one in Southern Pines, North Carolina, serving clients all over the area, and sometimes that includes helping them finding a competent, knowledgeable estate planning attorney. Again, thanks for watching. Hope you found this helpful.